pressed the Let's Go Live button, which means we've got to wait for the stream to fire up all across the fruited plain of the internet before we can go ahead and get started. We do have some serious business to attend to, but we can't do it until the internet is connecting the tubes, and it looks like it is. So hello to our friends over on YouTube. Hello to our friends on Rumble. Of course, we are on Twitter, Facebook, and our friends over at Locals. Looks like we're all alive across the fruited plains. So let's get right into it, shall we, my friends? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gouveia. I am a criminal defense attorney broadcasting from the Valley of the Sun deep in downtown Phoenix, Arizona. And today we're talking about Section 203. And we are going to dive into the case that is now coming out of the Supreme Court of the United States. You know this one as Gonzalez versus Google. And sometimes these Supreme Court cases can feel a little bit heavy, a little bit like, oh man, we're going through all this briefs and memoranda and petitions and oral arguments and all this stuff. But this one's kind of a doozy, okay? This one involves ISIS. It involves YouTube. It involves the murder of innocent civilians in France in 2015. It's like a crazy story. And it involves Section 230, because what's happening here is the family, Reynaldo Gonzalez family, is suing YouTube over the death of this woman, Nohemi Gonzalez. She was killed in 2015, ISIS attacks. We're going to go through her petition. We're going to take a look at the court docket. We're going to understand how the Google recommendation system works, because what they're explaining is that YouTube was essentially recommending ISIS videos for the ISIS attackers who ended up murdering, killing this Nohemi Gonzalez person. And they're saying YouTube's responsible for that, right? They were helping to radicalize these individuals who then led to the murder of that young woman back in 2015. So a pretty interesting story. Google also obviously is defending themselves, and they are relying on Section 230, which is a very, very important law because of, well, society and technology and free speech and all of these issues. We've been dealing with censorship. A lot of these big tech platforms have been responsible for that censorship, but they're also kind of part of the problem, but they're also kind of not part of the problem. It is a big mess. So the Supreme Court is listening to oral arguments on this. Google and their lawyers submitted their brief. We'll read through that along with a petition from the Gonzalez family before we really spend a lot of time on the oral arguments that took place today out of the Supreme Court, because there was a lot of actually interesting things going on. And we listened to some of this morning live at our members only stream, but there was more that came out today. We're going to check in with the petitioner. So this is the lawyer who is representing the family, the Gonzalez family. His name is Schnapper, and he delivered the opening arguments. We're going to hear from Judge Clarence Thomas, Chief Justice John Roberts. We got Judge Kagan, Sotomayor, and another Judge Thomas there before we turn our attention over to the Google lawyer. And the Google lawyer is also great. She's Lisa Blatt. She's the attorney for the big company, and they are, she got a bunch of questions from John Roberts, Ketanji Brown Jackson, another one from Kagan, and then we'll wrap up the segment with Neil Gorsuch, who I think is just great. So we'll go through all of those. Of course, there was another individual there representing the U.S. government, Solicitor General. We're not going to listen to him, but we do have a lot to get to, my friends. And so if you want to be a part of the program, the best place to do that was to go over to our amazing community at watchingthewatchers.locals.com. As I mentioned, we are doing member-only streams, member-only headlines. And so if you join us over there, then you get access to those. And of course, we're also beta testing right now our website, which is going to have a bunch of additional features. And we're launching right now a permanent chat, right? So although this live stream will end, our permanent chat goes on, my friends. So you can come and join us over there and get access to all of that, watchingthewatchers.locals.com. Also want to shout out our sponsors of the show, our friends over at fieldofgreens.com, where you can get your real organic superfood, eat healthy, get your daily servings of fruits and vegetables so that you can have more energy, your metabolism will adjust, your body will say, hey, let's go and do things and move, and you'll lose weight the healthier way. And it's a great product, tastes good going down. And you can save 15% off by using code Robert. And look what it does. It makes you feel, it doesn't actually do this to your hair, okay? Full disclaimer. But it does make you feel that way. I mean, I feel that way right now. I'm like, wow, where's all this energy coming from? I know where it came from. Field of Greens this morning. Field of Greens, 15% off with code Robert. All right. And also, I want to shout out our law firm, my former law firm. It's no longer mine anymore. It is the R&R Law Group. They're still doing great work. Of course, I'm no longer there. But if you know anybody in the state of Arizona who needs help with a crime, send them over there. They're going to take very good care of them. 480-787-0394. Online at rrlawaz.com. All right, my friends. Well, let's get right into it. We just have one section on the day, one segment on the day, I should say, rather. Section 230 now making its way through the Supreme Court. We can't wait to see what they decide, whether this will change the technology landscape all across the fruited internet plain of America. Only time will tell. But today we're going to go through this case in some detail because it involves a very interesting controversy that is around an incident that took place in Paris in 2015. That was the ISIS attack. You may remember this. And this woman was killed in that attack. Nohemi Gonzalez. Her family is the family that's the subject of a petition. They are suing Google. You see two people of the Gonzalez family here. Beatriz and Jose are standing in front of, I believe it's the Supreme Court, who are looking very regal and filled with fortitude to avenge their claim on behalf of Nohemi, and they're filing a lawsuit against Google. And of course, this involves YouTube. YouTube is a subsidiary of Google, and YouTube is where many of you are watching this right now. And so we have a lot of interest in this and how this works because Section 230 has been the subject of a lot of controversy. It seems like a lot of the big tech companies can kind of get away with whatever they want. They can censor people, they can ban, suspend, shadow ban, keyword filter, suppress searches, whatever they want to do. And when Congress calls them in to ask them questions about it, they just sit there and lie to them through their teeth and nobody does anything about it. And a part of their immunity comes from a very important law, which was written back in the 1990s called Section 230, which we'll look at in further detail because this is what YouTube is putting up as its force field to say we're immune from all of this. You can't sue us for your daughter's death. We didn't do anything involving her death. We didn't recommend any videos that radicalized ISIS. You can't sue us. We're immune from this. And so some people are saying they should be immune and it's not a valid claim. And other people are saying, well, maybe enough with this big tech stuff. Maybe they should be subject to some civil liabilities. And so we'll go through all of that before we turn our attention to the oral arguments that took place out in the Supreme Court today. A lot of clips from both the lawyers representing the family, the petitioner, the Gonzalez family, as well as the defense lawyer for Google, the respondent. And so let's take a look at what happened here in the first place. So how can YouTube be sued for an ISIS attack in Paris in 2015? Well, it comes from their recommendation engine, which we'll learn a little bit more about. What the family is saying is that YouTube recommended ISIS videos to the ISIS terrorists who ended up becoming radicalized because of those videos. They're on the internet and they're just, very nice, unassuming, nice little friendly, young men. And they're sitting there and suddenly they're on YouTube. Uh-oh. And an ISIS video pops up and they say, gosh, I was thinking about going into, hairstyling or something, but now I think I'll just go dedicate my life to rooting out the infidel, something like that. And they watch enough of these videos and they finally put on the black mask and raise the black flag and boom, you've got a whole new war on terror that's percolating around the Middle East. Not good. So what happened is ISIS attacked civilians in Paris in 2015. You may remember this story. Wikipedia gives us some background on this. They tell us that in 2015, the Paris attacks were a series of coordinated terrorist attacks that took place on Friday, November 13, 2015, beginning at 9:15, there was an international football match. Group of attackers fired on crowded cafes and restaurants in Paris, some of them dropping off explosives. A third group carried out another mass shooting at another event. Police raided the theater. The culprits killed 130 people, right? It was a catastrophe. 90 at the Bataclan Theater, another 416 were injured, almost 100 critically. Absolute, disaster. And this situation resulted in the death of this young woman. Her name was Nohemi Gonzalez. And what her family is saying is that YouTube recommended videos that influenced those terrorist ISIS sympathizers who literally killed her, and that YouTube should be responsible for that. Here's how YouTube recommendations work from the YouTube website. They say recommendations help you discover more of the videos you love, except our videos. They don't recommend our videos hardly at all. Many of you come here directly. Many of you share these videos. Thank you for doing that, because we talk about controversial topics. We talk about news that is not authoritative. And so what they do is they suppress us down. They actually tell us this. So we don't show up in these recommendations where everybody else does. You ever notice you're on YouTube and you see the same creators all the time? You're like, well, I don't even like this person. Why is his face all over my home feed all the time? That's because YouTube is elevating certain content that they want you to see that is mainstream approved, and they are suppressing the other content that is no-no land. That is very problematic for them. They're asking me for a nice little survey here. We'll leave that alone. So they have articulated this to us. This is part of the scheme. This is one of the criticisms of these big tech platforms, is that they're not really these neutral content providers, right? They kind of are putting the thumb on the scale. We have had our ebbs and flows on YouTube, and they don't like certain channels a lot more than they like other channels. And I think you'll find that same pattern amongst a certain sector here on YouTube. So here's their recommendations. They say, this is going to help you discover more of the videos you love, whether it's great new recipe to try or your favorite songs. And it's going to be fun listening to the Supreme Court justices who are trying to communicate about this. But if you've been on YouTube, right, they're going to talk about this. The reason I'm explaining this is so we can all follow along as the judges go through it. But, when you are on YouTube and you go to your homepage, they will say, you've watched 10 videos about baking a cake or gardening or something I've been watching videos about lately has been gardening. So I get all these gardening videos now. So they pop these videos up, and they're presuming I want to watch more about gardening, right? And here you have the same thing happening on their Watch Next. You watch a video about growing tomatoes. The next video will show you about whatever the next video is. And so the same thing is going on with here. Now, what they're worried about in this case is not gardening. They're worried about ISIS and those videos popping up and influencing people to engage in the war on terror on behalf of a terrorist group. So not ideal. So now that we have that background in place for us, I want to show you how many eyeballs are interested in this. How much attention has been brought down upon this. We're going to go through the Gonzalez petition, but first I want to show you what the Supreme Court docket itself looks like. This is directly from the Supreme Court of the United States. You see the cases Reynaldo Gonzalez, the petitioners versus Google. It was originally filed a long time ago back in, the decision from the lower court was in 2021. This was docketed on the Supreme Court last year, almost a year ago. So in 2022, it's been a long time. And there's been a lot of activity. So this first entry is with the filing from the family, right? This is, hey, Supreme Court, can you please, knock, knock, knock. Hey, can you please help us? And they said, actually, yeah, we can. On October 3rd, 2022, they said, yeah, hey, guess what? Your petition is granted. So they go, what? You're kidding me. Holy moly. That's crazy. That's almost never happens, right? Very rare thing. Amazing. This is going to be a big deal. And watch what happens. Motions to extend time. And then boom, all the amicus briefs start getting filed in. So these are all friends of the court. They're all saying, I want to be heard on this, judge. Can you hear me too, please? Can you listen to me? Liberty Justice Center filed their motion. A bunch of other people get permission to do it. The petitioners, the Gonzalez family, they file. We'll take a look at this. Here, the National Police Association files. Giffords Law Center to Prevent Gun Violence, they file. We're talking about ISIS videos and YouTube algorithms. Why is the Gun Center filing amicus brief here? Common Sense Media, we've got Fair Play, CITP Tech Policy. Josh Hawley filed a brief. Josh Hawley. Free Speech for the People filed one. We got Tennessee, Mayor Tamir Heyman filed a brief. United States, Cyber Civil Rights. Okay, look, the list goes on and on. I'm not going to read every one of them. Look at this list. Look. Here, it just keeps going. So we've got, Children's Advocacy, Integrity, Zionist Organization of America. Ted Cruz filed something here. America's Future. And the list just keeps going on. Reddit. Hey, Reddit moderators filed something. Shout out to our friends over on Reddit there. Wonder what they filed about. I don't know. Wikimedia filed something. We have Ron Wyden. We have Chamber of Commerce. Okay, like everybody and their friend. Facebook, Meta filed one. These are Electronic Frontier Foundation, Trust and Safety Administration. Craigslist is in the house. Microsoft, Yelp. All right, you get the picture. ZipRecruiter is in here. Cato, ACLU's in the house. They're all here. A lot of people. So a lot of eyeballs on this. They want to know what's going on because this could have a catastrophic, impact for them or not. It could just be, the Supreme Court just says, no, Section 230 is great. Thanks for playing. So I want to go through this in a little bit of detail here, given the magnitude of what could be coming. And for context, we also have another very sort of similar case taking place tomorrow. Supreme Court oral arguments are taking place tomorrow, the following day. And a very similar case, except it involves Twitter instead of YouTube, right? So the Supreme Court, when they issue their opinions on this, it'll likely be something that is covering both sides of the equation, both platforms, both cases. So now let's go through this in a little bit more detail so we can tease together what is going on. Filed in the Supreme Court of the United States, we have Reynaldo Gonzalez versus Google. This is the petition. So this is the document that is filed by the family. Of course, Nohemi is their daughter. May she rest in peace. They are saying, YouTube, you're responsible for the radicalization of the ISIS terrorists who killed her in Paris in 2015 because you recommended videos to them that radicalized them. And because you are the person who is recommending the videos, you're serving those videos up to them. You are a publisher. Section 230 doesn't apply to you, and you need to be punished for this activity. Of course, they've got big pockets, so they will recover nicely if the judge finds in their favor. So we have a question. To the Supreme Court, they ask, all right, Judge, Section 203C1, which we're going to look at in greater detail, is a big part of the law, and they say there's a question about this. Does that section immunize content providers when they engage what they call traditional editorial functions, like as whether to display or withdraw information? All right, so as we talked about on the YouTube recommendations, you go to YouTube. YouTube itself as a company, well, you're watching this video right now. There's a bunch of other videos on the sidebar or underneath wherever it is you're watching this. YouTube put those there, right? YouTube decided that. And I don't know what they are showing right there next to you. Shout out to maybe Viva is usually there, or maybe another legal video or something. Whoever is there, is there because YouTube is saying, well, these are similar pieces of content and you guys should watch the same type of stuff, right? So if YouTube is making that decision, shouldn't they be responsible for what is up there? Let's see what this says. We'll fast forward through the table of contents and the table of authorities. We'll get right into the meat and potatoes, fast forward through jurisdiction and the statutory provisions. Let's see if we can get to maybe a statement of facts. There it is. Here is where we want to start. The statement of the case, now this is from Gonzalez versus Google. They say that, all right, Judge, and this is like the first document that lands in front of the Supreme Court judges. They're explaining why this case should be accepted. We already know it has been accepted, and so we'll just take a quick look at what the basis for this is. They say the enactment of Section 230 was prompted by prior decisions, and they give us some background on that. And they say that Section 230C1 provides the following: no provider or user of an interactive service shall be treated as a publisher. And they're trying to define what this means. They say, now, In the decades since the enactment of Section 230, the types of services on the internet has been changing dramatically. The issue in this case has arisen out of some of these fundamental changes. Specifically today, the income of many large interactive computer services is based on advertising, not on subscriptions like they were previously. The financial structure has given rise to widespread practice of recommending, for want of an agreed upon better term, and they're going to fight over this term here, a different material to website users. They make recommendations based on algorithms which review the content and then make the recommendations. Pretty obvious, right? You've seen this many times. And so there were a bunch of proceedings that took place below. There was a complaint that came forward that alleged the following. In November 2015, Nohemi Gonzalez, 23-year-old citizen, was studying in Paris, France. She was murdered when 3 ISIS terrorists fired into a crowd of diners at La Belle Equipe Bistro in Paris. This tragic event was part of a broader series of attacks that was perpetrated by ISIS, which also included several suicide bombings and mass shootings. Ms. Gonzalez was one of 129 people killed during the rampage. Now, several of Ms. Gonzalez's relatives, as well as her estate, subsequently brought this action against Google, which owns YouTube, a global service which publishes videos. Don't forget to like this video and subscribe. The plaintiffs allege that Google, through YouTube, had provided material assistance to and aided and abetted ISIS conduct forbidden and made actionable by the Anti-Terrorism Act. Right? Families saying YouTube is like literally supporting ISIS here. Now, that complaint alleged that assistance and aid took several forms. How is YouTube assisting ISIS? How could this even be? 1. Family says that Google had knowingly permitted ISIS to post hundreds of radicalizing videos inciting violence and recruiting potential supporters to join ISIS. YouTube just allowed that to happen. They reference footnote 2, which doesn't tell us much. They say, additionally, they also say that Google affirmatively recommended ISIS videos to users. So you're on there, you're watching, let's say, a video about the war in the Middle East. I wonder what's going on over there. What kind of tanks and equipments are being used? Oh man, that's crazy. So that new missile has that functionality and it works like this. You know, you ever gunned down those rabbit holes, right? Shout out to my fellow, rabbit holers out there, right? We've all done that, okay? And now you get an ISIS video that pops up and says, are you also fed up with American chauvinism throughout the world? You go, yeah, I kind of am, And so they're saying that recommendation is an affirmative recommendation to somebody. You're sitting there watching videos about, Hummers, and then you have another video about ISIS attacks using whatever equipment they're using, and it's close enough that it makes it up into your watch next video. So they say third, they also there were recommendations were one of those services that Google provided to ISIS. ISIS uploaded, they got their videos recommended just like the rest of us. Google selected the users to whom it would recommend the videos based on what Google knew about those users, and it targeted those users with characteristics that said that they would be interested in ISIS videos. This person is watching a lot of, they're not quite beheading videos, but they're close. It's like something similar. So they recommend it. The selection of the users to whom the ISIS videos were recommended was determined by computer algorithms created and implemented by Google. Because of those recommendations, users were able to locate other videos and accounts related to ISIS, even if they did not know the correct identifier of the original YouTube account had been replaced. So once somebody gets one video, then boom, it goes down this giant rabbit hole. The complaint alleged that the services that Google provided to ISIS included these recommendations. They say it was critical to the growth of ISIS. And in fact, Google was helping them grow rapidly. Google services played a uniquely essential role in the development of ISIS's image, in its success in recruiting members from around the world. And I actually remember this. I remember thinking, I don't know if you had this experience, but I was watching some of their videos. And I think at the time, I think I was just getting into video, like on YouTube. Like our first video on this channel was published, I think in 2015, a long time ago. And I was watching the quality of my videos and I was thinking, this is pretty terrible. And if you've ever gone back in the history library on this channel, they're pretty bad. But ISIS videos were like 4K with like flashy video, flashy cuts and like, drone footage and graphics all over the place. And I'm like, man, their content's even better than my content, not good. Anyways, so they were all over the place and their videos were getting a lot of views. A single ISIS video had 56,000 views in a 24-hour period, man. That's more than this channel gets, man. YouTube is recommending ISIS more than they're recommending our channel. Oh, gosh. It's official now. It's in the Supreme Court record. I guess. I don't know. I mean, look, I can't do that type of content, okay? This is not going to be an ISIS channel. I just can't do it, okay? I can't do it. I'm not into that type of stuff. But all right. I guess that's how it is. I guess we'll just keep making videos. Maybe they'll recommend us one day. Videos that users viewed on YouTube were the central manner in which ISIS enlisted support and recruits from different areas. To utilize YouTube in this manner, ISIS established a sophisticated recording facilities. It's true, they did. And although the recommendations were made based on computer algorithms, the complaint alleged that Google officials, now they say they were well aware of the company's services and they were assisting ISIS. All right, so now, I want to, sort of separate out another issue. Okay, let's say we have this facially neutral algorithm that is recommending certain things and you identify, okay, well, now it's recommending ISIS content. Should we go in there and put our thumb on that? Should we, push down on that little area? Because now we're sort of becoming sort of publishers because we're not just giving you the raw data. We're now sort of manipulating a little bit. We're sort of deciding what is appropriate to censor, because in this case, it was ISIS. Let's say it's ISIS in this hypothetical, but in Twitter land, when we were going through the Twitter files, it wasn't ISIS. It was, some guy making a joke about the elections being on a Wednesday instead of a Tuesday, boom, account suspended, right? As we saw yesterday when we were reading through Undead Foya and his Substack, he was explaining that many of these people who were labeled as Russian bots and Putin stooges were just everyday American citizens. So somebody in big tech is always going to call somebody ISIS, right? I guess is my point. And where do you draw these lines? It's complicated. But in this case, the complaint is saying, the family is saying, all right, look, Google has had extensive media coverage, extensive complaints, legal warnings, congressional hearings, other media platforms. Prior to all of this, they've been taken to task and they have refused to do anything about it. Refusing to actively identify ISIS YouTube accounts as reported by other YouTubers. Right? This kind of has like all the same echoes of the Russian hackers, being alleged on existing on Twitter. You're not going to allow Putin stooges to be on there. You know what I mean? So the complaint alleged that the assistance provided to ISIS by Google was a cause of the 2015 attack. But for YouTube, if YouTube had not existed, or if YouTube had done something about those ISIS videos, then those ISIS individuals would have never been radicalized. The terrorist event wouldn't have happened in 2015, and young Nohemi would still be alive and with us. Thank you, YouTube murderers. So Google moved to dismiss the complaint on the ground that Section 230 barred all of your claims. They said, like, we're not creating that content. We're just sorting it and distributing it. That's all. No different than a search engine. So they say with regard to some of these claims, they appealed it and the Court of Appeals said a bunch of stuff. And now they say the court should grant the petition for a writ of certiorari, right? And they're saying, okay, you guys need to hear this and deal with it because we have some conflicts on how the different lower courts are handling this, and they need the Supreme Court to step in. They say that here in this case, the family is asserting that Google, with full knowledge and the nature and consequences of its actions, repeatedly recommended ISIS videos to users likely to be susceptible to the calls for terrorism. And we can pause just on this concept for a minute. Okay, YouTube really does have a pretty dang good algorithm, right? That's why it has so many viewers. That's why when you go on your homepage, you open up your phone, you get the 8-pack of the videos or the 5-pack of the videos, 10-pack, and you see, okay, well, I kind of am interested in like 7 of the 10, right? Those are the recommendations. It's usually a pretty high number. You almost never open it up and you go, I don't want to watch anything on here, because they know you pretty well. They know what you like, what other things you click, how long you watch other videos, and all of this gets fed into the algo. So they say, yeah, this person likes legal content. This person likes this topic, but not that topic. And they pull the videos to feed them to you. So if they suspected that somebody was, I guess the algorithm really wouldn't care necessarily on the content as much as it does the watch time, the click-through rate, the thumbnails, all of the other things. So it puts it in the same universe. And they are specifically feeding people now content, so it's not only ISIS content, but it's also content that the viewer is most inclined or most likely to be moved by, right? They're going to click it because they are sort of primed for it. The algorithm's great. That's why we're here. Many people are on YouTube. Here, and did so at a time when ISIS recruits were in a combat with forces in the United States trying to conduct mass killings. So the family says, construing Section 230 to protect recommendations made by YouTube would virtually preempt all non-criminal, non-federal laws and so on. YouTube algorithms, they write, have extraordinary impact. YouTube, for example, is used by a majority of the adult and teenage population in the United States. Yeah. That's why everybody is on YouTube, and by hundreds of millions of others around the globe. Mounting evidence, they say, as another judge provided, can nudge susceptible souls down even darker paths, right? Because they're giving you more of what you want. So they say, although the events giving rise to this action occurred in 2015, we now know through subsequent reporting that YouTube is still recommending violent and extremist materials. All right, this is where I start to get irritated. Okay, well, how do you define that? What is violent and extremist? Because that is a very dynamic definition, and I don't like where that definition has landed as of late. Recommendations encourage users to look at terrorist videos, they say. And so they say the important should be the one that this court should settle is whether Section 230 should be construed to protect these recommendations by computer services. All right, so that's kind of what we're focused on. Are those recommendations within the confines of Section 230? Let's take a look at the question presented one more time and see what they had for us there. Unless I passed it already. Yeah, I think I did. Anyways, okay. So that is the filing from the family. We'll take a look at the filing from Google. Here it is. Yes. Here's the question presented. Does the recommendations, targeted recommendations, is that within the confines of Section 230C1? All right. So before we get to the opinions or the questions from the judges, let's take a look at the question from Google, or Google's response. And before we dive into Google's response, let's refresh our memory on what Section 230 looks like in the first place, since we're going to be spending a lot of time listening to the judges talking about it. You can see here, this comes from our friend over at Cornell. U.S. Code, Title 47, U.S. Code 230, Section 230 is the law. And a lot of this is very irrelevant to what we're talking about. We'll fast forward through the findings. Okay, the findings aren't really the law. It's just Congress saying, this is why we did the thing. They're going to let us know why they did the thing. Okay. They also tell us their policy position in Section B. Well, this is the policy of the United States. And so, when you're looking at a statute like this, you'll hear different judges talk about interpreting this in different ways. You'll hear Ketanji Brown Jackson asking about the title, right? Well, what about protection for private blocking and all of that? And then you'll hear, because she's sort of a full picture type of interpretationist. And then you'll have somebody like Gorsuch who says, well, what does that specific law say right there in that sentence? Does it say anything about that? No, then it doesn't apply, right? Not considering the broad picture, getting down into the nitty gritty and the specifics, somebody more who is a textualist. So all of this is here. We see the real question pertains to section C, which is about the treatment or the publisher or the speaker. It says no provider or user of an interactive computer service shall be treated as a publisher or speaker for information provided by another content provider. Okay, so it's a lot of legalese, but it's basically saying if you post something on YouTube that's a problem with the law, YouTube's not responsible for it, you are. It gives them that force field. And so we're going to be fighting over that. Well, what about these recommendations? Okay, because the recommendation didn't come from you or me, right? I'm not in control of the recommendations. I wish I were. I'd get as many views as ISIS, I guess, maybe. So we have a situation where YouTube is creating that information. They're creating that content. They're gathering it all up and they're generating it on their own accord. So why aren't they responsible for that, is what the family says. And so we'll take a look at Google's response. They, of course, have submitted a brief. Before we turn our attention over to all of what the judges had to say in oral arguments today, but first, let's make sure we're nice and healthy and we're attending to our well-being and healthcare by talking about our friends at Field of Greens, because as we all know, we'd all like to lose some of those leftover pandemic pounds and Super Bowl pounds and rainy day pounds. But how sick are you of all those ads for weight loss pills and fad diets? We've all been there. We've all done that. And they don't work. But you know what does? Eating 5 healthy servings of fruits and vegetables every single day. You do that and the weight probably just starts to fall right off. But I know vegetables, not a fan. Who's got time to prepare all of that every day? But you don't have to, because we can talk about Field of Greens, which is a science-backed formula seen right here on your screen, of fruits and vegetables that you're not going to find in any other product. Proper nutrition reboots your metabolism so you burn calories the faster way and lose weight in a healthier method. And the Field of Greens is the only brand backed by a better health promise. Yes, you're going to look better and you're going to feel healthier, but the best proof is going to come at your next checkup when your doctor says, my goodness, you've lost weight. Whatever you're doing, keep it up. All right, so let's get you started. Head on over to fieldofgreens.com. Don't forget to use code Robert to save 15% off your first order at fieldofgreens.com, where code Robert will save you that 15%, and you will just be bursting with energy, and it's going to feel amazing. Trust me. And it tastes good going down. I have mine right here. Field of Greens. This is the one that has caffeine in it. Upstairs is the one that does not have caffeine in it. And there's all sorts of other great products there at fieldofgreens.com. Thank you for supporting our friends. All right. And so now let's get right back to it, my friends. Google, of course, responded to this, and they submitted their own brief, which we should pay attention to before we get into the oral arguments from the Supreme Court. Google responds, you see this in their brief of the respondent, which in this case happens to be Google. This brief is 68 pages long, and so we'll go through this relatively quickly before we turn our attention over to the judges. But Google is framing this as follows. They say, the petition framed the question presented as the following: are we, YouTube, immunized from our recommendations? They give us the table of contents, their authorities. We're going to go down until we see their introduction and statement. Here it is. The brief for the respondent, this is Google writing. They say, the internet lets billions of people instantly access, share, and contribute to a vast and ever-growing universe of information. Each day, users worldwide generate over 500 million tweets, 294 billion emails, 4 million gigabytes of Facebook data, and 720,000 hours of new YouTube content. To make this mountain of third-party data usable, Google says websites have to do a couple things like filter, sort, and organize it all. Virtually all websites from Amazon to Zillow accomplish this unprecedented task using algorithms, obviously. Computer programs that, in the words of Google's founding mission statement, organize the world's information and make it universally accessible and useful. Recommendation algorithms are what make it possible to find the needles in humanity's largest haystack. They say the result of these algorithms is unprecedented access to knowledge, from life-saving how to perform CPR to the mundane, best pizza near me. Google search uses algorithms to recommend top search results, and YouTube uses algorithms to share everything from cat videos to Heimlich maneuver tutorials, algebra problem-solving guides, and opera performances, but definitely not watching the watcher's videos. Oh, they put that in there? Huh. Services from Yelp to Etsy use algorithms to organize millions of user reviews and ratings, fueling global commerce, and individuals' users like and share contents millions of times every day. In the mid-1990s, the growing number of people uploading and sharing this content created a serious legal challenge. At the time, defamation law and other state law torts defined publishers as anybody who broadcasts, but that was a problem. Why? Everyone online could have been a potential defendant at any time they disseminated someone else's content. Reaching everyone at once also meant potentially falling under multiple state laws as well. And so they articulate the problem. So to address this dilemma, what did they pass? Section 230. Bum, bum, bum. So in this case, the people who filed this, the petitioners, they say that YouTube violated the Anti-Terrorism Act by displaying ISIS videos to users watching similar videos. YouTube abhors terrorism and over the years has taken increasingly effective actions to remove these videos. But they say, even though we've done that and we've tried to clean all of this up, Section 230 still prevents the family's claims. Why? YouTube provides a website that allows people to publish videos, and they use algorithms to sort those videos. And petitioners now say that Section 230 bars their primary theory below. They are upset about two different features. One, of course, is the up next feature. Okay, you're watching one of these videos. The video ends, another video automatically gets queued up and gets popped up on your screen. What happens if that's an ISIS video that says, why don't you come join our jihad? Petitioners and the government are also talking about their recommendations. And Google is explaining that they're trying to define the lines. All right, what falls within Section 230C1 and what doesn't? Do the third-party videos fall inside the line or outside the line? Is Google responsible for those or not? Is Google responsible for the recommendations or not? How about the comments or not? How about the likes or not? How about the notifications or not? How do we tease all of that out? You see them here. Messages, product listings, files, and other information. So we have questions about how all this works. And Google is giving us their opinion, which we'll listen to in oral arguments. But in summation, their memo tells us this court should not undercut a building block of the modern internet and basically find that there are no valid claims here by the petitioners. Let's see how they close this out in conclusion. And they want all of the claims saying they violated the Terrorism Act should fail. Signed by Lisa Blatt. We're going to hear from her in oral arguments, and she is coming out of a DC law firm. And that makes sense because she sounds like she's got some experience in this arena. Okay, so those are the two briefs that we saw. One from the Gonzalez family. Of course, they're filing on behalf of Nohemi Gonzalez versus YouTube and Google. And so now let's turn our attention over to the oral arguments that took place out of the Supreme Court today. Now, there were three people presenting today. We have the presenter for the petitioner, which is the Gonzalez family, which is this gentleman, Mr. Schnapper, who we're going to listen to. There's also Lisa Blatt, who we just heard about, representing Google. There was also the Solicitor General representing the government. We're going to fast forward through him and sort of skip over him. But he was also somebody, if you want to go listen to his arguments, you can. But today we're going to start off with Gonzalez. And so there was a short opening statement. They kept these very short and the judges jumped right into questioning. So I want to start off with the attorney for the Gonzalez family, detailing why the family should succeed, why YouTube is responsible for the death of Nohemi.
We'll hear argument this morning in case 21-1333, Gonzalez versus Google. Mr. Schnapper.
Mr. Chief Justice, and may it please the court, Section 230C1 distinguishes between claims that seek to hold an internet company liable for content created by someone else and claims based on the company's own conduct. That distinction is drawn in each of the three sections of the statute. First, Section 230C1 is limited to claims that would treat the defendant as a publisher of third-party content. The statute uses publish in the common law sense. The Fourth Circuit decision in Henderson correctly interprets the statute in that manner and concludes that it involves two elements. The claim must be based on the action of the defendant in disseminating third-party content, and the harm must arise from the content itself. Second, Section 230C1 is limited to publication of information provided by another content provider, which is often referred to as third-party content. The statutory defense doesn't apply insofar as a claim is based on words written by the defendant or other content created by the defendant.
Okay, so what he's doing here is he's basically saying the statute is pretty narrow. Okay, we talk a lot about the scope of the statute, and the analogy we like to use is the hula hoop. You remember those games as a kid, like you put the hula hoop around somebody else, or like capture people, like lasso somebody, or whatever those games are. It's kind of like that. Okay, what type of conduct can we say falls within the protection of Section 230? In this case, YouTube is like everybody. Everybody's inside my Hulu. Everything we do is protected. We're immune. We have this force field that immunizes us from any claims. And this guy is saying, no, that's not true at all. Okay, look at the statute. He just articulated, it's like these three limited circumstances. Okay, you're protected if you do this and this and that. Everything else, though, okay, like recommendations, no, it's not in there. It doesn't say, it's not in 1, 2, or 3. It's not in the law. So how can you just continue to expand this well-defined hula hoop and keep, growing it to a degree that nobody even recognizes anymore? That's not right at all. And that's his opening argument and going to be the main theme of his line of questioning with the judges that we'll explore today. So the first one comes out of the gate from Clarence Thomas, who usually doesn't talk all that much in these oral arguments, but he has been talking in more recent years. And he had some serious questions about the algorithm itself, okay? Whether this is sort of a facially neutral algorithm or whether this is an algorithm built to amplify ISIS content. The way I think that Justice Clarence Thomas was thinking about this is sort of like neutral limitations on speech. We have free speech, and then we have time, place, and manner restrictions, and then we have content restrictions on speech. And of course, things that are content restrictive are unconstitutional because they're limitations on your free speaking rights. But time, place, and manner restrictions, right? You can't shout at a bullhorn at 2 a.m., outside of somebody's house, near City Hall or something, protesting. No, you can protest, but not right here, right now, right? And tomorrow at this time, you're allowed to do that. And a lot of those rules have been upheld. So here, I think Clarence Thomas is sort of asking about that. Well, is this algorithm impacting the content, or is this just kind of a neutral algorithm that just also happens to be amplifying ISIS content? Is YouTube creating algorithms, in other words, that promote this content? Is that what you're saying?
I welcome the court's questions.
Mr. Schnapper, just so we're clear about what your claim is, are you saying that YouTube's application of its algorithms is particular to, in this case, that they're using a different algorithm that to the one that say they're using for cooking videos, or are they using the same algorithm across the board?
It's the same algorithm across the board.
So what is, if it's the same algorithm, I think you have to give us a clear example of it, what your point is exactly. Is the same algorithm to present cooking videos to people who are interested in cooking, and ISIS videos to people who are interested in ISIS, racing videos to people who are interested in racing, then I think you're going to have to explain more clearly, if it's neutral in that way, how your claim is set apart from that.
Surely. If I might turn to the practice of displaying thumbnails, which is a major part of what's at issue here. The problem and the issue is not the manner in which YouTube displays videos. It actually displays, as you doubtless know from having looked at, these little pictures, which are referred to as thumbnails. They're intended to encourage the viewer to click on them and then go see a video.
Yeah, that's why we make all those
faces.
faces.
The use of algorithms to generate these thumbnails that's at issue. And the thumbnails, in turn, involve content created by the defendant.
But it's basing the thumbnails, from what I understand, is based upon what the algorithm suggests the user is interested in. So if you're interested in cooking, you don't want thumbnails on light jazz.
Unless you're cooking to jazz.
So it's neutral in that sense. You're interested in cooking, say you get interested in rice and pilaf from Uzbekistan. You don't want pilaf from some other place, say Louisiana. I don't see how that is any different from what is happening in this case. And what I'm trying to get you to focus on is are we talking about the neutral application of an algorithm that works generically for pilaf, and it also works a similar way for
jazz
ISIS videos?
Yeah, and jazz.
Or is there something different?
No, I think that's correct. But our view is that the fact that an algorithm is neutral doesn't alter the application of the statute. The statute requires that one work through each of the elements of the defense and see if it applies. The lower courts, in a couple of cases, have said that, really disregarding the requirements of the defense, that as long as an algorithm is neutral, that puts the conduct outside within the protection of the statute. But that's not what the statute says. The statute says you must be the claim must treat you as a publisher.
A very interesting argument, actually. I have to say it. We're looking at it from both sides now. Okay, so let's put our hat on YouTube's side. Okay, we want to look at it in the light most favorable to them. They've got all this content. They don't know what to do with it. So they're just coming up with this neutral algorithm that serves up some content. If it happens to serve up ISIS, they say, well, we're not serving ISIS. Okay, we're immune from this. We didn't specify, watch this ISIS video, but the algorithm did. And so the publisher is the person who actually published the video. YouTube and Google are just resorting it and then showing it to you. That's it. How could they possibly be responsible for that? And they're looking at it almost from an algorithm perspective. And they're saying that Section 230 gives them immunity there because they are looking at it from that angle. Now, he's taking the opposite approach. He's looking at it from in this case, actually not the algorithm at all. He says, I don't care what the algorithm, he doesn't even care about the algorithm, okay, essentially. He says, I care about the outcome, and what Section 230 says are these three things. And if it doesn't hit these three things, then the immunity doesn't apply. And the outcome in this case is harm. In this case, right, there was a terrorist attack and she was injured, and YouTube did the conduct. He doesn't care if the algorithm published the recommendation or somebody named Yoel Roth published the recommendation. Okay, or anybody else just said, oh, I'm going to put that one there and I'll put that one there. And there's some guy back there with a bunch of cards and he's just throwing out recommendations into the next pot, right? He doesn't care. It doesn't matter. It doesn't matter what it is. It just doesn't meet those three elements. And so he's, again, taking this as a very, very strict, narrow interpretation. And it's interesting, right? The judges are focused on the technology. He doesn't care about the technology. He cares more about the outcome. And so this now goes over to Chief Justice Roberts. He says, yeah, but what about like the video content versus the thumbnails, right? Now we have to sort of deconstruct this to another layer. So YouTube makes the recommendation. The recommendation then will show you a thumbnail. The thumbnail, does that radicalize you, or does the content? So now if we're going to take this one step further and you click the video, you got to watch the video, and the video that you watch is going to be the thing that radicalizes you, right? So how can YouTube be responsible for the content? All they're doing is showing you the thumbnail, then you click the thumbnail because that's your volition thing, right? The user clicks the thumbnail. You make the choice to go over there and watch the content. You stick around as they talk about jihad and you know, whatever. And it is your decision. So why should YouTube be held responsible for that?
I mean, the difference is that the Google, YouTube, they're still not responsible for the content of the videos or text that is transmitted. Your focus is on the actual selection and recommendations. They're responsible that a particular item is there, but not for what the item says. And I think it may be significant if the algorithm is the same across, as Justice Thomas was suggesting, across the different subject matters, because then they don't have a focused algorithm with respect to terrorist activities or PLOF or something. And then I think it might be harder for you to say that there's selection involved for which they can be held responsible.
The statute, I think, doesn't draw the distinction that way. The claim here is about the encouragement of users to go look at particular content. And that's the JASTA claim that we'll hear about tomorrow. And the underlying substantive claim is encouraging people to go look at ISIS videos would be aiding and abetting ISIS.
Aiding and abetting ISIS. So saying that, in other words, you would not have watched that video but for YouTube. Okay, you're sitting there watching a video on military equipment in the Middle East, boom. The algorithm thinks, because the algorithm is very smart, and I've actually read breakdowns of this, that YouTube will, I don't know if this is true or not, obviously, but I've read it, that they deconstruct every piece of content frame by frame and sound by sound. Okay, I mean, they basically, the same thing they do with their crawlers to index the internet. When they index the internet in the old way, I don't know exactly how they do it now, but they would just follow a link. You link to that website, website links to another website. So it would just follow the links. Whatever website had the most links pointing to them means they had a lot of authority. A lot of people liked them. They ranked higher in the index, and boom. Same thing kind of happens with the videos, is they just break down the video. Every single frame, every single text is optical character recognized. They are basically, they know exactly what's in the video, whether you say it verbally, whether it's in text, whether it's a chat comment, it's all in there. And so it all matters. And we have a lot of questions about what part of that process is protected, what part of that process is not protected. And he's essentially saying that those recommendations are matching up, you know, the military equipment in the video that you'd like, you see the same thing in the ISIS video, and that's why it pulls the ISIS video. So we have more questions. Justice Kagan is asking about these algorithms, and she says, you know, the internet was kind of very new back in the 1990s, and we didn't even really have that many algorithms at all. And so this was kind of a pre-algorithm situation, wasn't it? Now we have very complex algorithms. We've got ChatGPT, we've got artificial intelligence, we have all of these different technologies that are making it even more powerful and maybe identifying people who are even more susceptible to ISIS influence. Do you think Section 230 was supposed to be that broad and powerful to protect all of these rights of publisher of these big tech platforms?
This was a pre-algorithm statute, and you know, everybody is trying their best to figure out how this statute applies. The statute, which was a pre-algorithm statute, applies in a post-algorithm world. But I think what was lying underneath Justice Thomas's question was a suggestion that algorithms are endemic to the internet, that every time anybody looks at anything on the internet, there is an algorithm involved, whether it's a Google search engine or whether it's this YouTube site or a Twitter account or countless other things, that everything involves ways of organizing and prioritizing material. And that would essentially mean that, you know, 230, I guess what I'm asking is, does your position send us down the road such that 230 really can't mean anything at all?
I don't think so, Your Honor.
In other words, you're reading it too narrowly, right? If it's only like these three protections, like you came in here and said this, this, and this, everything else they're liable for. We can sue them on all of these other things. And she says, well, if that is the case, I mean, if that's what you do, doesn't that cause serious problems for all of the existing tech companies?
The question, as you say, algorithms are ubiquitous, but the question is, what does the defendant do with the algorithm? If it uses the algorithm to to encourage people to look at ISIS videos, that's within the scope of JASTA. It's not different than if back in 1996, a lot of clerks somewhere at Prodigy did this manually. And just they had a bunch of file cards and they figured out who was interested in what. The statute would have meant the same thing there that it does now. It's automated, it's at a larger scale, but doesn't change the nature of what they're doing with the algorithm.
I'm sorry, finish.
The brief, I think the briefer respondent points to a number of uses of algorithms, for example, to pick the cheapest fare or things like that. That's just outside the scope of the statute. The algorithms being used there to generate additional content. So the question is what you do with the algorithm.
And in that case, in the YouTube case, they're saying, well, algorithms are okay, right? The algorithms are great. But in this case, it was serving terrorist content in violation of the Anti-Terrorist Act, right? Which is it's not supposed to do that. And so since it doesn't meet those three elements of the law that he says are what is necessary to invoke immunity by the big tech companies, he says they don't have a force field. Shields are down. Let us sue them for the death of this woman. And, she's an American citizen. They've got, jurisdictionally, they're through those hurdles. And so maybe if they could make the claim that YouTube did influence this or was some cause of this, or at least, aiding and abetting ISIS through the promotion of their videos, maybe they can make some serious money back from YouTube. Now, we have a long exchange here. We have a good sort of summary from Judge Sotomayor. She is asking Mr. Schnapper to walk us through this complaint, explain it like I'm five, which I think actually turns into a pretty interesting conversation by the end.
It's the recommendation practice that we think is actionable.
Can I break down your complaint a moment? The vast majority of it is paragraphs after paragraphs after paragraph that says they're liable because they failed to take ISIS off their website. I think, as I'm listening to you today, you seem to have abandoned that and are saying they don't have to take it off their website. Am I correct about that?
That's exactly right. That
So that
is the way
can't
we
be-
framed the question presented. We
So that
did not
can't
advance
be-
that claim.
So you're abandoning that claim.
Okay, so the claim was that the original claim, it sounds like, was YouTube is problematic if they are promoting ISIS content and they don't remove it, right? It was like those two things. Now it's not that at all. If it's just they promote it through the recommendations, that alone is enough.
So that can't be aiding and abetting. So I think I'm listening to you. And the only aiding and abetting that you're arguing is the recommendation, correct?
That's correct.
You're not arguing that some of these providers create chat rooms or put people together, users together. You're not claiming that that's part of what you're arguing about? The social networking, I want to call it.
Well, that's not an issue in this case.
It's in tomorrow's case.
Twitter's
All right.
tomorrow.
If I
All
could
right,
be
so
more
you're
specific,
limiting- you're limiting
Facebook
your-
does that.
All right.
Facebook recommends people,
Right.
which is very difficult to find within the four walls of the statute. Google's created a lot of things, but so far.
But you're not claiming that in this case. You're just
that's not what-
focusing.
No, this is about content, it's not about.
This is about content. And I just want to focus your complaint so I understand it very clearly. You're saying the YouTube or the next up feature of the algorithm that says you viewed this and so you might like this. It's you might like this that's the aiding and abetting? What part of what they're doing? Because, whoever the user is types in something, they get an ISIS video, you say that's okay, they can't be liable for you, the viewer, looking at the ISIS vehicle, but the internet providers can be liable for what?
Okay, so
For showing me the next video that's similar to that?
All right. It would be helpful perhaps if I distinguish between two kinds of practices that go on at YouTube. The complaint doesn't describe them in detail, but we're fairly familiar with them. So
I'm glad, but I'm going to be looking at your complaint because it can only survive if the complaint is adequate.
It's
So
kind
you're
of a
going to have
lame.
to tell me where in the complaint you're saying this.
That's
if
kind
I'm
of
gonna
lame.
think about holding them liable.
Okay, that's kind of lame. That's kind of like a judgy thing that judges do. It's like, well, in this conversation, they're exploring a lot of these topics. Okay, it's hypotheticals. Well, what about this? And what about this? And oftentimes what the judges will do is they'll take a string, like a string on a guitar, and they'll just pull it all the way back, and they'll just wang, and they'll just let it twang back just to see what it sounds like. They'll pull an argument and just really see what it feels like. And that's okay. You're allowed to do that. That's kind of the point. You want to take one variable of the argument and really amplify it or minimize it to see what it does to the underlying argument. And so here, Sotomayor is sort of saying, well, if you didn't say that in your original complaint, we're not going to consider it here, which is like, okay, technically that might be true, but also, Judge, are you serious right now? It's like, it's a technicality thing, and nobody cares about the technicalities. You're the Supreme Court, so don't scold him about the technicalities. Just let him explain the argument and then say, okay, well, but that's not what you're arguing here, though, right? But that does illustrate a principle. Anyways.
So you're going to have to separate out the two things.
I'm about
then.
3 questions behind. Let me
All right.
let me try to do my best here. So what we've been talking about up until now is the use of thumbnails to encourage people to look at content. People haven't clicked on any video yet. And our contention is the use of thumbnails is the same thing under the statute as sending someone an email and saying, you might like to look at this new video. Now, the up next feature is a different problem. And the problem there is that when you click on one video and you pick that one, YouTube will automatically keep sending you more videos which you haven't asked for. That, in our view, runs afoul of a different element of the statutory defense, which is that they be acting as an interactive computer service. And when they go beyond delivering to you what you've asked for, to start sending things you haven't asked for, our contention is they're no longer acting as an
All right,
interactive
so
computer
even
service.
if I
They're different.
accept that you're right, that sending you unrequested things that are similar to what you've viewed, whether it's a thumbnail or an email, how does that become aiding and abetting? I'm going back to Justice Thomas's question, okay, which is if they aren't purposely creating their algorithm in some way to
If it's
feature
neutral.
ISIS videos, if they're, I mean, I can really see that an internet provider who was in cahoots with ISIS provided them with an algorithm that would take anybody in the world and find them for them and do recruiting of people by showing them other videos that will lead them to ISIS. That's an intentional act, and I could see 230 not going that far. I guess the question is, how do you get yourself from a neutral algorithm to an aiding and abetting,
Right.
an intent, knowledge? There has to be some intent to aid and abet. You have to have knowledge that you're doing this.
Yes.
So how do you get there?
So if the algorithm recommends an ISIS video or it automatically plays it, that, as we'll see tomorrow, that by in itself isn't going to satisfy aiding and abetting. Aiding and abetting requires knowledge that it's happening. So the elements of the aiding and abetting claim, which we'll be talking about tomorrow, address the question you're asking. If this was teed up, if they didn't know it was happening, and the other elements of an aiding and abetting claim were present, they would not be liable for aiding and abetting.
Thank you, counsel.
All right, so
It's the recommend-
they knew it is essentially what he's saying. And so, I think the argument is a little bit weak as we continue on with this. He's sort of saying that he would, there would be a claim even if YouTube didn't do anything about this. Oh, my mind map froze. All right, we're going to have to pause for a quick minute and reopen the mind map. Having some serious technical difficulties out here today. No doubt about it. All right, so we're pulling this up. The point that I was going to make is that we're trying to draw the lines between, when does Google become liable, and the justices are having a difficult time teasing it out themselves. We're going to wrap it up on this segment before we turn over to the Google lawyer from Judge Clarence Thomas one final time. This is the family's attorney, Eric Schnapper.
Was that responsive? I'm not.
Well, it's responsive, but I don't understand that you called. I mean, if you called,
I think that was Amy
information
Coney
and
Barrett.
asked for
I think it's Amy Coney Barrett in the laughter category. Eric Schnapper is answering a question. Judge Thomas says, "Is that He asks Judge Thomas, "Is that responsive?" Judge Thomas says, "Well, I mean, it's responsive, but I don't understand it. I mean, you said something, but I don't know what it was."
Was that responsive? I'm not.
Well, it's responsive, but I don't understand that you called. I mean, if you call information and ask for Abadati's number and they give it to you, I don't see how that's aiding and abetting. And I don't understand how a neutral suggestion about something that you've expressed an interest in is aiding and abetting. I don't understand it. And I'm trying to get you to explain to us how something that is standard on YouTube for virtually
regular
anything
algorithm
that you have an interest in suddenly amounts to aiding and abetting because you're in the ISIS category.
Well, again, I'll be answering that probably again tomorrow. But as little as what you described without more probably wouldn't. But as we'll learn tomorrow, the circumstances are far different than that. These YouTube and these other companies were repeatedly told by government officials, by the media, dozens of times that this was going on, and they didn't do anything. They did almost nothing about it. That's very different than providing one phone number through information.
Well,
But it goes to the scope of JASTA, not to 230.
So we've gone from recommendation to inaction being the source of the problem. And this is what I'm...
Great point by this very brilliant judge, Judge Clarence Thomas. All right, what is the problem here? They're saying it was the recommendations. Now they're saying it's inaction. So can Google make a recommendation and then take it down and that's okay? Or no? Because earlier he said the same thing. He said that no, I mean, it's really not about the removal. It's just about the mere recommendation. And so Judge Thomas is having a difficult time following as well.
I understand you're putting it in context, but it's hard for me to also to understand where this obligation to take specific actions can lead to an aiding and abetting claim.
Well, the interconnection in this case is that we are focusing on the recommendation function, that they're affirmatively recommending or suggesting ISIS content, and it's not mere inaction. Mere inaction might work under aiding and abetting, but we'll get there tomorrow. But the claim that we're focusing on today is that in fact they're affirmatively recommending things. You turn on your computer, and the computers at YouTube send you stuff you didn't ask them for. They just send you stuff. It's no different than if they were sending you emails.
Yeah, but you did kind of ask for it, right? I mean, you open the YouTube app expecting those recommendations to be there. You kind of use it continually. You keep coming back because of the recommendations, right? It doesn't really matter what you use. Even the YouTube Shorts, right? The reason you continue to watch the YouTube Shorts is because the recommendations are making recommendations of other content you want to continue to watch. If they were showing you completely unrelated things, it would be a bad experience and you wouldn't use it. So you kind of do want it. It's not like it's completely unsolicited. So I'm not sure I really buy that argument all that much either. But Interesting. I do have to say, quite interesting that they are going this route. Very sort of strict constructionist approach on the statute and applying the content or conduct to the statute. I like it. I actually think it's a very interesting argument. Now, let's see how Google responds to this. Representing the Google team, we have Lisa Blatt, who delivers opening arguments or opening statements to the Supreme Court.
Ms. Blatt?
Mr. Chief Justice, and may it please the court. Section 230C1's 26 words created today's internet. C1 forbids treating websites as, quote, the publisher or speaker of any information provided by another. Publication means communicating information. So when websites communicate third-party information and the plaintiff's harm flows from that information, C1 bars the claim. The other side agrees Section 230 bars any claim that YouTube aided and abetted ISIS by broadcasting ISIS videos. So they instead focus on YouTube's organization of videos based on what's known about viewers, what they call targeted recommendations. They say that feature can be separated out because it implicitly conveys what viewers should watch or that they might like the content. But accepting that theory would let plaintiffs always plead around C1. All publishing requires organization and inherently conveys that same implicit message. Plaintiffs should not be able to circumvent C1 by pointing to features inherent in all publishing.
So she's saying we organize the data, okay? We've always organized the data. They're trying to circumvent this a little bit because we're organizing it in a new and novel way, but it doesn't necessarily undermine the original concept behind the immunity and the protection in the first place.
C1 reflects Congress's choice to shield websites for publishing other people's speech, even if they intentionally publish other people's harmful speech. Congress made that choice to stop lawsuits from stifling the internet in its infancy. The result has been revolutionary. Innovators opened up new frontiers for the world to share infinite information. And websites necessarily pick, choose, and organize what third-party information users see first. Helping users find the proverbial needle in the haystack is an existential necessity on the internet. Search engines thus tailor what users see based on what's known about users. So does Amazon, TripAdvisor, Wikipedia, Yelp, Zillow, and countless video, music, news, job finding, social media, and dating websites. Exposing websites to liability for implicitly recommending third-party content defies the text and threatens today's internet. I welcome your question.
All right, so another short opening statement from Lisa Blatt, and we've got several clips. Now, the judges are also, again, focusing on algorithms and recommendations. We're going to check in with Judge Roberts first, and he is sort of getting clear on this word recommendations. What does this mean? Are you like, is it like a recommendation, like a hard recommendation from a friend, or is this just sort of a term of art? How's this all working?
Says that their claim is limited, as I understand it, to the recommendations themselves. In other words, this is the list of things that you might like. But that information, the recommendation, is not provided under the words of the statute. It's not provided by another information content provider. It's provided by YouTube or Google. And so, although whatever the liability issue may be, there's some issue tomorrow, we'll talk, there are a lot of others, the presence of an immunity under 230C, it seems to me, is just not directly applicable.
Well, that's incorrect because of the word recommendation. There is no word called recommendation on YouTube's website. It is videos that are posted by third parties. That is solely information provided by another. You could say
I'm not so sure about that. I mean, it is on their website.
any posting is a recommendation. Anytime anyone publishes something, you could be said it's a recommendation.
Well, the videos just don't appear out of thin air. They appear pursuant to the algorithms that your clients have, and those algorithms must be targeted to something. And that targeting, I think, is fairly called a recommendation, and that is Google's. That's not the provider of the underlying information.
So nothing in the statute or in the common law of defamation turns on the...
Yeah, so they're kind of fighting over words here. Now, I do think that that's kind of a stretch. She said nothing on YouTube's video, a website talks about, says recommended videos. And I think maybe on the homepage, he's sort of right about that, right? Like, I don't think on the sidebar it says recommended to watch next, but this is YouTube's website. This is how YouTube works at youtube.com, all right? It says here, recommended videos. They have a whole section on exactly how it works. So, again, it's not the crux of the argument. It's kind of mincing hairs about definitions. But Judge Roberts, I think, was right about that. What are we talking about? You're talking about recommendations, and the argument is that YouTube is coming up with the recommendations, right? It's not the user. Like I said, if I could go and influence what everybody got recommended, we'd get a lot more views on this channel. But we don't have that authority, okay? I can't do it. Nobody else can do it. Only YouTube can. And so that's kind of a product that they're creating and that they're delivering to the people who use the service. Why should that be protected if it's in violation of the law, is essentially what Judge Roberts was asking. So now let's turn our attention over to Ketanji Brown Jackson, the newest addition to the court, former defense attorney. She asks some questions of Google's lawyer, says the following.
Isn't there something different to what Congress was trying to do with 230? Isn't it true that that statute had a more narrow scope of immunity than courts have, ultimately interpreted it to have, and that what YouTube is arguing here today, and that it really was just about making sure that your platform and other platforms weren't disincentivized to block and screen and remove offensive content. And so to the extent that the question today is, well, can we be sued for making recommendations? That's just not something the statute was directed to.
So can I take this in two parts? Because I feel
I think somebody just opened a soda pop. Did you hear that?
like your first part of your question is addressing what the dispute is between the parties, and the second part of your question goes most deeper, and which is, beyond the question presented. But just on your first question about why do you need an immunity as opposed to liability? And in our view, that's like saying, that's death by 1,000 cuts, and the internet would have never gotten off the ground if anybody could sue every time, and it was left up to 50 states' negligence regime. And let me give you an example.
Yeah.
A website could put something alphabetical in terms of reviews, and every Young, Williams, and Zimmerman, i.e. XYZ, could say, well, that was negligent because you should have rated it somewhere else.
No, I totally understand that, but I think my things are not actually different. What I'm saying is that problem that you identify, which is a real problem, the internet never would have gotten off the ground if everybody would have sued, was not what Congress was concerned about at the time it enacted this statute.
Well, so that's correct. That's incorrect for a number of reasons.
Yeah.
And we can talk about what two choices you're talking about. There's only two.
Now, she's got a little bit of confidence here. Did you hear that? She's calling out these Supreme Court judges. She told Judge Roberts, no, that's incorrect. And she's just told Ketanji here, you're also incorrect here. I'm liking this.
Arguments on the table for what you could think that C1 does, and that is, it simply says, no interactive computer service shall be treated as a publisher. And you could think, well, there are two ways of looking at that. One is that you need an external law that has publication as an element, and then second, which I think that your question may be going to, is it only directed to eliminating forms of strict liability across all causes of action? And so both of those ways are highly problematic and also inaccurate given what was happening in 1996. In terms of just looking at this as, is this just talking about defamation? It plainly can't be, because the statute would be a dead letter upon inception, because any defamation cause of action can be repled as negligence or intentional infliction of emotional distress. So we think the word treat, which means to regard, applies whenever the claim is treating the or imposing liability because by virtue of publishing. In other words,
but what do you do with the title and the content and the context?
Ketanji.
Right? The title of Section 230 is Protection for Private Blocking and Screening of Offensive Material.
She wants to talk about everything.
let me just pinpoint then the section.
She also, many of the liberals on the court, they also want to talk about like their high school professor's opinion that one time they had at that college coffee shop. They're like, yeah, but what about that too? What about the title? And what about that legislative history from back in 1937 that was, created back in the 1800s that also came from this guy back in the 1600s? It's ridiculous. You go, All right. What does the law say right here? Good Lord.
Second one, which hopefully we'll get to on section E, which is all the exceptions. But in terms of the title, Stratton, Oakmont, and restrictions, C1 and C2 are a pair.
All right. And we also have an interesting dynamic here because it sounded like some of what Ketanji was talking about was this concept of immunity versus liability, right? On the one hand, the big tech companies, they want immunity. They don't want to be sued. They don't want any lawsuits to even start because you can imagine if you're a small internet company back in the 1990s and you even have to face one lawsuit, that's a very expensive thing to deal with, right? You've got to come out of pocket and hire lawyers to defend on these lawsuits. And so if you have a website with millions of users, you might be subjecting yourself to millions of lawsuits. And yes, you might win every single lawsuit, right? You might come out victorious on the other end of it, but you still got to defend it. And so what Section 230 was intending to do, in theory, was to prevent those lawsuits from coming so that people weren't hit with an onslaught of litigation to protect themselves. So immunity is much more important than liability for them. Like they may be not liable for anything, but they still have to come out of pocket to defend themselves. Immunity prevents them from having to do that. So we have two more clips. We've got Judge Kagan, who is asking about a pro-ISIS algorithm. Okay, so let's again pull on that guitar string. Let's just turn that knob all the way up to level 11. We know in this case, YouTube didn't have any ISIS algorithms out there. But what if they did? What if they had just created an ISIS algorithm? Would that change this equation, or would they also be immune from that, right? I mean, it's if they have protection when it's not an ISIS algorithm, what if it was a pro-ISIS algorithm? Would you still have that?
Suppose that this were a pro-ISIS algorithm. In other words, it was an algorithm that was designed to give people ISIS videos, even if they hadn't requested them or hadn't shown any interest in them. Still the same answer that a claim built on that would get 230 protection?
Yes, except for the way Justice Sotomayor raised it, which is material support. So if there's there's a criminal exception. So if you have material support in collusion with ISIS, that's accepted from the statute. But if I can just take the notion of algorithms, either they're raising...
But what I take you to be saying is that in general, and this goes back to Justice Thomas's very first question.
Yes.
In general, whether it's neutral or whether it's not neutral, whether it is designed to push a particular message, does not matter under the statute, and you get protection either way.
That's correct. And I'm just referring, I agree with what Justice Gorsuch said, except for he was saying that somehow the Ninth Circuit was at fault because it recognized this was an easy case. It's not the Ninth Circuit's fault that the complaint said, there's nothing wrong with your algorithm. You just kept repeating the same information independent of any content. And so we shouldn't be faulted because his complaint doesn't allege anything wrongful. No. But in your hypothetical, where someone could say, and again, this is always going to turn on the claim, but let's just think of, I don't know what your hypothetical would be about tortious speech, but the bookstore example, you could decide that you want to put the adult book section separated from the kid section.
You can have an adult algorithm and a kid's algorithm, and YouTube does have a kid's algorithm, and they do have an 18+ algorithm.
Biased choice, and I'm doing scare quotes for the transcript.
Or how about an algorithm that looks for defamatory speech and puts it up top, right? And you're still saying 230 protection.
So our test, when you look at the claim, and so if you have a claim for defamation, is always going to look at the claim and say, is the harm flowing from the third-party information or from the website's own conduct or speech? And so if I can mention the race example, that's an excellent example of the claim has nothing to do with the content of the third-party information. It can be...
Right, but the claim would have something to do with the content of the information. It would say, my complaint is that you just made defamatory speech available to millions of people who otherwise would never have seen it. And you're on the hook for that. That was your choice. That's your responsibility. Why should there be protection for that?
Well, so if there's some sort of misrepresentation or some sort of terms of service that you weren't going to do that, but let me give you an example where this opens up a can of worms, is because you could say that about any content, that you elevated the most recent content. I mean, search engines and of all kinds, including Google search, but all the amici briefs are telling you, they have to make choices. They've got an undescribable amount of content, and it has to be based on something, whether it's relevance to a user request, a search history. If it says headache, the Microsoft example, do you want something from the 1300s, or do you
got to
want
do
something,
something with
that's a
the
little more
data.
recent?
Like
Okay, but
there's a
what
user
if-
interface.
I'm sorry, but I just want to make sure, in just
Amy Coney
Kagan's
Barrett.
example, what if the criteria, the sorting mechanism, was really defamatory or pro-ISIS? I guess I don't see analytically why your argument wouldn't say, as Justice Kagan said, that, yeah,
You're still
230
protected.
applies to that.
Yeah, you're still
Well,
protected.
I mean, it's similar to your 303 case. You can make a distinction between content choices in terms of how you would organize or deal with any kind of publication, whether it's a book, a newspaper, a television channel, that kind of stuff, and that is inherent into all publishing.
Right,
Because,
so you're saying 230 does apply to that? 230
Yes.
gives protection
yes,
regardless?
I hope I didn't say something
Yeah.
incorrect.
230 gives protection
Yes.
regardless, whether it's like put the defamatory stuff up top, put the pro-ISIS stuff on top, or whether it's, what people might consider a more content-neutral principle.
It's an interesting question. Like, what if these algorithms are specifically created to bubble up problematic content? Section 230 would still apply, is what she's arguing, I think, unless it hits another exception under the law, which would be some sort of criminal exception or defamation by another claim. But Section 230 would provide broad immunity regardless.
Correct. And let me just say, you have websites that are hate speech. So they may be elevating more racist speech as opposed to some other speech that talks about how the equality of the races. You might have a speech devoted to, an interest of a certain community, like an ethnic community. So they may be saying, you know what, we don't want to put some other kind of content. We may want to publish it, but we may want to put it further down on our algorithm. And if you said, again, this is a content distinction. If you have a claim that
So I can't imagine that, and then, we're in a predicament here, right? Because this is a statute that was written at a different time when the internet was completely different. But the problem that the statute is trying to address is you're being held responsible for what is another person's defamatory remark. Now, in my example, you're not being held responsible for another person's defamatory remark. You're being held responsible for your choice in broadcasting that defamatory remark to millions and millions of people who wouldn't have seen it otherwise.
You're retweeting
through
it.
This pro-defamatory algorithm. And the question is, should 230 really be taken to go that far?
Yeah, can you protect that person? What if somebody just creates an algorithm that just, besmirches your good name and honor all day? And they start a company and it's just besmirching you, and everybody just besmirch, you call it besmirch.com or whatever. And it just is created for this. And you can just say, oh, sorry, Section 230. I can do whatever I want. I'm protected by the law. She's saying that's kind of nuts, isn't it?
the question is, can you carve out pro-defamatory as opposed to pro-anything else, pro some other type of content that someone may be suing over negligence? If I can just give you an example of a TV channel. When you broadcast an excessively violent TV channel, you're giving it a new audience that they wouldn't otherwise have. It's still inherent to publishing. And if you decide to run reruns of the most sexually explicit and violently explicit, you could say that's a bad thing, and it may be, but on your choice, but it would be protected under 230. In terms of what was happening in 1996, I strongly disagree with the notion that algorithms weren't present based on targeted recommendations. The Center for Democracy and Technology has this wonderful history lesson of what was happening in 92 through 94 on how targeted recommendations developed. And you had something called news groups, which were, for anyone using...
Yeah, and they go down a history lesson of all the ways that, you know, all of these things were organized and situated. And of course, you're familiar with that. But the point is, we're asking ourselves about who's moving the things around and where are these lines being drawn. And so we're going to close out this today before we turn it over to the Supreme Court and await their opinion. But our final clip is from Judge Neil Gorsuch, who's outstanding. And he says, well, okay, well, what is this like creation of information concept? He says, all right, you know, when we're making a video here or doing a live stream, certainly we're creating content, right? It's coming out of thin air. And there's a process that goes into it. We got video and audio, and we're creating something new. And we publish it on YouTube. But YouTube is now taking all of this content, aggregating it, and then it's sorting it. But is that sorting of the data, is that creating new information? Is this creating new content, the sorting and the displaying of the data? Because if that is the act of creating content, then maybe that might help us answer these questions. We could then say, oh yeah, YouTube is in fact a publisher and they should not have immunity. They should be liable for some of this stuff because they are creating content much in the same way we are doing it here and now. So Gorsuch asks a little bit about that. And I think we get an interesting exchange here. And I like this exchange, okay? This Lisa Platt is very confident here in front of the Supreme Court. I don't know what her background is, or if she's appeared here before or what, but she is telling these judges that she's even unhappy with them. Listen to this.
I kind of want to return to some of the questions I asked earlier. It seems to me inherent in C1 is a distinction between those who are simply interactive computer services and those who are information content providers. And so when we flip over to F, the distinction I glean from that is that if you're picking, choosing, analyzing, or digesting content, which is the bulk of what how you describe Google's activities in a search engine context.
Recommendations, algos.
And that content must be something more than that. Providing content must be something more than that. Is that right, in your view?
I thought you were absolutely correct, and I think some of the amicus briefs do this. In terms of if you're looking at what is information being created or developed, there is that distinction. It can't be that you, by sorting, you created or partially developed the information. So I think you had it
filtering and
exactly
sorting,
right.
it's not enough.
I got a little upset when you talked about a remand that somehow the Ninth Circuit got it wrong.
Well, let's go there next then.
Did you hear her? She said, I agree with you, Judge. You were right about that, but I was upset with you when you did this other thing. And he says, all right, you want to talk about that? Let's talk about it.
Content, which is the bulk of what how you describe Google's activities in a search engine context, are protected, and that content must be something more than that. Providing content must be something more than that. Is that right, in your view?
I thought you were absolutely correct, and I think some of the amicus briefs do this. In terms of if you're looking at what is information being created or developed, there is that distinction. It can't be that you, by sorting, you created or partially developed the information. So I think you had it exactly right. I got a little upset when you talked about a remand that somehow the Ninth Circuit got it wrong.
Oh.
Well, let's go there next then.
Okay.
Because it seems to me that even under that understanding of the statute, there is some residual content for which an interactive computer service can be liable. You'd agree with that that's possible?
Not on this complaint, because
No, of course not on this complaint, but in the abstract, it's
absolutely
possible.
correct.
Okay.
She's tough.
And then when it comes to what the Ninth Circuit did, it applied this neutral tools test. And I guess my problem with that is that language isn't anywhere in the statute.
Of course not.
Number one. Number two, you can use algorithms as well as persons to generate content. So just because it's an algorithm doesn't mean it can't generate content, it seems to me. And third, that I'm not even sure any algorithm really is neutral. I'm not even sure what that test means, because most algorithms are designed these days to maximize profit.
Obviously.
There are other...
Yeah, to maximize watch time or click-through rate or conversions or anything.
For examples, Justice Kagan offered some, the Solicitor General offered some, where an algorithm might be contain a point of view, even a discriminatory one. So I guess I'm not sure I understand why the Ninth Circuit's test was the appropriate one and why a remand wouldn't be appropriate to have it applied, the test that we just discussed.
Because it's not, I don't think that was the Ninth Circuit's test. It was one sentence that was, maybe I think it mentioned it twice. It's basically, almost making fun of the complaint. The complaint doesn't...
Okay. So we're just disagreeing over how we read the Ninth Circuit's opinion. But if I read it that way, then would a remand be appropriate?
Listen.
Well, I'm going to say no, because I don't understand how
he
somehow
laughs.
that they have a bad complaint means the Ninth Circuit's worse off. When the Ninth Circuit said over and over and over, this is just the way you're organizing it, and the complaint never alleges there was something independently wrongful about the content. It never says these were colloquial recommendations. It just says because you previously liked this content. And one other thing, the complaint never even alleges that the YouTube ever recommended to any, in terms of even displaying an ISIS video, to anybody who wasn't looking for it. I don't even know how you could get ISIS on your YouTube system unless you were searching for it. And the one
I certainly understand your complaints about the complaint. But
he doesn't want to talk about it.
You don't think neutral tools, you're not defending the neutral tools principle either, as I understand it.
Okay, so he just cut her off. I don't know if you caught that, but she started to go on a tangent. He says, okay, look, stop. I know you're upset about the complaint. That's not what I'm asking you about. He's being very gentle about it, but this is a fun exchange. Okay, so let's play that one more time. She's going off on a tangent, and then he cuts her off, and then he's going to cut her off hard here to close this out. Watch.
how you could get ISIS on your YouTube system unless you were searching for it. And the one
I certainly understand your complaints about the complaint. But if you don't think neutral tools, you're not defending the neutral tools principle either, as I understand it.
I'm defending it with respect to Justice Kagan's question, absolutely, because she's concerned about biased algorithms, and she doesn't have to worry about that in this case because...
So Judge Gorsuch is a little... He's interested in what the Ninth Circuit did. They're having disagreements about the Ninth Circuit test, which is this sort of neutral standards test. And this sort of also harkens back to what Clarence Thomas was talking about, and this idea that if it's a facially neutral algorithm, then maybe that's acceptable. But if it's not facially neutral, if it is biased, then that's a problem. And so Gorsuch is saying, all right, I want to know what your position is on the Ninth Circuit case and on that standard. And she's sort of flailing around a little bit. She's no. I actually love that standard when it applies to Kagan's question, but not as it applies to sort of these other things. And Gorsuch is trying to really pin her down on this, and watch how it ends up. It's fun.
As I understand it.
I'm defending it with respect to Justice Kagan's question, absolutely, because she's concerned about biased algorithms, and she doesn't have to worry about that in this case because they have neutral algorithms. They don't allege, and what they mean by neutral algorithms is neutral with respect to content. So there's Okay.
Thank you.
Thank you.
Thank you. We're done. Stop talking. Got what I needed. No more questions. Thank you. And he said that loudly over the phone so she could hear it, and she just shut up right there. Did you notice that? All right. I'll stop talking. And so she picked up on that near the end that he didn't want to hear about it anymore. So, of course, my friends, there will be a lot more on this tomorrow. There is a Twitter case that's going to be percolating tomorrow at the Supreme Court, oral arguments on that, because YouTube was the subject of today's inquiry. But tomorrow, Twitter will be back. And so, of course, we'll continue to cover this. We had a lot of Supreme Court stuff today. We'll see what we have tomorrow. Thank you for liking this video. Thank you for subscribing wherever it is you're watching this. And we'll look forward to seeing you on the next one. But that, my friends, is it for the content on the day. Let's take a look at what you guys had to say over from our friends on YouTube. And I apologize to our friends on Rumble. I don't know what I did, but apparently Rumble didn't start today. So I thought the tubes had connected themselves, and the tubes did not connect themselves. And so I apologize to our Rumble friends. I was a little bit, had some tech problems today that I was dealing with. But our friend Zulu is in the chat. Zulu says, as a lawyer, what are typical damages for an unfair Mafeelies, though, reclaim? Just a ballpark figure. Well, I mean, this one I'm looking at right here is not that much. Unfair Mafeelies, though, with 3 E's. I mean, that's like not that much. 3 E's, I don't know. Probably, what I would do, Zulu, my legal advice is to just substitute the re's with zeros. All right, so this would be like $1,000 claim for this re. If it's like, like a lot of re's at the end of it, like I would say, like this claim right now is like $1,000. No, like this one here is like $1,000 right now. But if you took like the reing over like, I don't know, like Adam Schiff, Adam Schiff reing over Kevin McCarthy turning over the J6 footage to Tucker. That's probably like 15 or 18 different E's at the end of the re. So if you go over to Adam Schiff's account, it's like 10 to 15 of those E's. So probably, I don't know, a few $1 billion is what Adam Schiff's reclaim is what he would be saying it's worth. is how I would contest it. So in this one, it's not that much. Now, in this Google claim, I'm also not real sure what I would value this one at. I don't even know what they're asking for, to be honest. Yeah. So anyways, so Zulu is here. Thank you, Zulu. Thank you, Zulu. I appreciate you, my man. Thank you for sending those in. Yeah. 2 super chats. I'm going to refresh over that. Zulu sent another one and cracked me up as I was reading those. And what is going on with this? Maybe it's my browser. Zulu said, LMAO, Rob, best answer ever. You're the man. Thank you, Zulu. I appreciate your support, brother. Thank you so much for sending those in. You're a lot of fun. Your super chats are always fun and funny. K Bean says, Don Lemon can help Google if you're past your prime, ladies. Oh, gosh. Yeah, we talked about that, about the Don Lemon situation on our members only stream this morning, and I don't want to broach that topic again. I almost got myself in trouble over there. Maybe I did get myself in trouble. I don't know. We're still having to deconstruct that stream. Yeah, but Don Lemon, very, very woke, very sophisticated, very inclusive, somebody who would never, never be misogynistic or somebody who would be chauvinistic in any way, shape, or form, had a little bit of an issue there when he was on CNN talking about Nikki Haley running for office. And so that came from our friend K Bean. Yeah, got to tiptoe around those issues. We'll just continue to just, blame Don Lemon and not talk about it here. Yeah, Don Lemon, K Bean says he's 56 years old, man. It also applies to bros too. It's like, how would it feel if you're a bro out there and somebody's like, yeah, you're a little soggy around the midsection there. Okay. You liked you better when you were 26 there, pudgy, it goes both ways, Don Lemon. And, we'll see what he's up to out there. Anyways, so that was from K Bean over there. I appreciate it. And we had Zulus in the house and everybody else. And so I apologize once again to our Rumble friends. Let's see what's going on over on Twitter before we wrap it up. I'm running a little bit late today, so it's going to be just a short check-in over on Twitter. And then we'll jump off on our after party for a brief moment or two. But Paul Mino is over there with our Happy Tuesday GIF in the house. And that's about how I feel when my tech doesn't work sometimes. That's about right. James Pepper says, YouTube suggested videos to me all the time of ISIS, but it was suggested. So I don't buy their story. Oh, man, yeah. And so, yeah, Al Holman says, yeah, Rumble wasn't working, but we're working here. Charles says, huge case. Thanks for covering it. Danny says, Robert, caught you on Twitter. Good to see you, Danny Bryan. We're glad that you're all over there on Twitter following us along. But all right, my friends, so that is going to be it for us. We are going over briefly to watchingthewatchers.locals.com. Come on over there and join us for our short after party. Of course, we'll be back with our headlines for members only tomorrow morning. But we'll hang out for just a quick minute and say our goodbyes. We also want to thank our sponsors of the show, our friends over at fieldofgreens.com, which is where you can get your real organic superfood. It's got broccoli and beets and all sorts of organic, delicious fruits and vegetables. It's amazing goodness. Tastes great going down. Go to fieldofgreens.com. Don't forget to use code Robert to save your 15% at fieldofgreens.com. Also, want to shout out my former law firm. Of course, I'm no longer there anymore, no longer one of the R's out there. However, they are still doing amazing work helping good people charged with crimes in the state of Arizona. And you can find them available at rrlawaz.com or at 480-787-0394. They got an amazing team of people standing by and ready to help. Also want to thank the mods and the meme smiths who make the show possible. Our friends Vienticus Prime, K Bean in the house, Just Cause. Of course, we got Playing Hooky, Ronnie Cole, Zulu, and Geomancy in the house. And I want to also give a shout out to our friend Zach Nichols, who's been doing a great job helping out with the onboarding of our Google Spaces chat. We're sort of beta testing this and trying to see if it works for everybody. But Zach, I appreciate your help, my friend. So thank you for being so useful on our perma chat. We also have our friends Sleepy Dog Lee, who is on Twitter. Shout out to Paul, and Geegum Geegum over on Locals. Grateful for all of your help. But that, my friends, is it for us on the day. And so we are going over to watchingthewatchers.locals.com to hang out for a little bit before we wrap it up on the night. I hope to see you there. But if not, we will be back here tomorrow to do it all again. And I hope to see you there so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Have a tremendous evening, my friends. I'll see you right back here tomorrow. Bye-bye.